We are going live. Good morning, sir.
Good morning, ma'am.
Yes, sir. Good morning to everyone present here, and it gives me immense pleasure to welcome eminent personalities on last day of webinar on IPR industry academia and innovative practices. I welcome our distinguished speakers of the day, Dr. Rahul Taneja and Mr. Abhishek Awasthi. I also welcome our principal cum assessment and accreditation ambassador, Dr. Kiran Angra, various principals of Menti colleges, my friends and colleagues of Menti colleges, NAC coordinator Mrs. Nishu Bansal, my cherished IQAC and NAC team, and other dignitaries present here. Dear friends, it's a wonderful day and we have joined together under the umbrella of Paramash scheme to discuss most important feature of NAC, that is IPR. I feel overjoyed and my gratitude goes to Dr. Angra for giving all of us this wonderful opportunity to organize such an important webinar on Introduction to Industrial Designs and Industrial Designs Industry Perspectives under the Paramash scheme of UGC. Dear friends, today's webinar is organized in collaboration with Chaudhry Ishwar Singh Kanya Mahavidyalaya Dhan, and it is my proud privilege to introduce Dr. Rahul Taneja to all of you. I am delighted to introduce the resource person of today's webinar, Rahul Taneja, who is working as a scientist, Department of Science and Technology, Government of Haryana, Panchkula. He holds professional degree including Doctor of Philosophy in Pharmaceutical Sciences. He is Master of Intellectual Property Law, Master of Pharmacy, Master of Business Administration, Postgraduate Diploma in Intellectual Property Rights and Patent Practices, Master Trainer of European Patent Office and World Intellectual Property Organization, and Postgraduate Diploma in Drug Regulatory Affairs and Clinical Trials. As a scientist at the Council for Science and Technology, he facilitates the micro, small, and medium enterprises of Haryana and Chandigarh for IPR related issues. His portfolio further categorically includes dealing with patents, including PCT applications, drafting, filing, and other prosecution included consultancy. Trademarks including convention applications, search report analysis, documents inspection, filing, trademark 60 NOC caution notice, and implementation of IPR enforcement rules at custom for seizure of counterfeit goods, including consultancy. Designs, filling reply of examination report, and copyrights. Dr. Taneja also selected as Bentham Brand Ambassador 2018-19 by Bentham Science Publications. He is also promoting and facilitates the research scholars, doctors, and scientists for the protection of intellectual property rights and to protect their invention and innovation as well. Dr. Taneja has also delivered 5 times live broadcasting on news channels to enterprises of Haryana cluster and 2 radio talk on the day of World Intellectual Property Rights Day. He has owned intellectual property in which 4 copyright, 2 industrial design, and 3 patent filed in his own credibility. He has also awarded as signification contribution in healthcare by All India Institute of Medical Science, New Delhi. He has 35 journal publications on various IPR issues and concepts, besides articles in various newspapers and newsletters as well. He has delivered more than 250 specialized lectures in various national and international conferences and training programs on intellectual property rights in various institutions and industrial associations, including Ministry of MSME, Micro, Small and Medium Enterprises, Development Institutions, Karnal, Micro, Small and Medium Enterprises Development Issues, Ludhiana, National Institute of Technology, Kurukshetra, Guru Jambheshwar University, Delhi, Punjab University, IT University, BPS Mahila Vishwavidyalaya, Chitkara University, Shulini University, PhD Chamber of Commerce and Industries, and so on. Sir, we are very delighted to have you with us, and it's a great honor for us to listen to you.
Thank you so much, ma'am.
Thank you, sir. Now the dice is yours, sir.
Kindly allow me to share presentation.
Sir, you can share.
Where it is shows host disabled participants screen sharing.
Okay, sir. Just okay, sir. Sir, you are co-host now, so you can share.
Thank you. Respected principal ma'am, Dr. Kiran Angra ma'am, Dr. Anurada ma'am, Dr. Nisha Bansal ma'am, my friend Dr. Ashwini Siwal, other speakers, faculty members, and dear students. So basically, you are listening IPR lecture from last 4 days, and you have experienced so many examples of IPR, how it is important for our country, how it is important for our nation. But my opinion is how important it is for the individual also, and it is also important for our nation. Especially, we are facing a Corona COVID-19, and we are facing so many problems in nowadays. And as our honorable prime minister said that we are focusing on vocal for local and Atmanirbhar Bharat. For the Atmanirbhar Bharat, we have to specialize, concentrate on the what is the need of our country. And nowadays, the need of our country is the innovation and invention. Without innovation and invention, our country cannot grow. I will show you the data where is our country stand in the field of intellectual property rights. If we can compare with the other countries, especially to America, China, and we are talking about China doing a lot of things, America doing a lot of things, but they people are very good in the field of the inventions and innovation. They protect every small things by the protection of intellectual property rights. My slide is visible to all of you.
Yes, sir. Yes, sir.
Thank you. Intellectual means creation of human minds. Property, the rights to have only some tangible things. Like there are two types of properties. Tangible properties, like you have your own house, properties, vehicles. You have some rights on your properties. Similarly, we have intangible rights. Intangible rights, we have a different type of intangible rights. Some are scientists, some are designers, some are musicians, some are technocrats. Some are protecting different type of layouts of the integrated circuits. Some are designing a new type of artistic work, phonography works, and some type of literary work. So government of India with the help of trade related aspects of intellectual property. What is the trade related aspects of intellectual property? Government of India has which signs GATT, that is the General Agreement of Trade and Tariff, in which they sign the agreement with for the trade only. After that, they have signed trade and services. Services basically to protect the services of each country and to facilitate of other countries to facilitate and indulge all the services provided by other countries. Now, after that, Government of India, with the help of World Trade Organization and TRIPS, they have signed intellectual property rights, in which they have seven different type of intellectual property rights: patent, trademark, industrial designs, geographical indications, layout designs, trade secrets, protection of new plant varieties, and copyrights. Every right has their own subject matters. Means every protection depends on the subject matter of the invention and innovations. Sometimes few things are covered into the patent, few things are covered into the design. It depends on the subject matter. Similarly, like the tangible properties, few things can be protected. Like if you are purchasing a new house, then you can protect by the protection by the urban local bodies by the registration. But if you are purchasing a new vehicle, for you have to approach to the RTO office for the purchase of new vehicle. Means like tangible properties, you have to approach different offices, different act for the protection of their subject matters. Likewise, in the intellectual property, first one is the patent. I think many speakers already had discussed about the patent, but in brief, I will discuss about few things about the patent. Maybe just for the revision, patents and exclusive rights granted for an invention and innovation. You will get a no periods for the 20 years from the date of filing. Nobody can use your invention without your permission. Nobody can sell your invention without your permission. You will get a right for the 20 years from the date of filing, not from the date of the grant. Most of the people get confused from the date of the filing or from the date of the grant. Your right is start from the date of the filing. You can claim your right is start from the date of the filings. But it's the basic criteria for the patentability. All the patent act basically depends on these three parameters: novelty, non-obvious, and industrial applicability. Novelty means your invention cannot be published anywhere in the world before the filing of the patent application. Means nobody can, that thing must not be disclosed only, not only in India, even across the country, across the world. That thing must not be disclosed to anywhere, neither in any literature, nor in any form, any literature, not in any written form, any journal publication, etc. Means that thing must be having some new concept in your invention. Inventive step means that thing must be non-obvious in nature. Non-obvious means the invention must have some technical advancement or economical significance or both. It depends on your product or process. You can file a patent application of product as well as with the process. It is not necessary your invention must be complex or complicated. You can also file the patent application of simple things, but that must be sure that your patent application can be fulfill the criteria of novelty, inventive step, and industrial applicability. Last one is the industrial applicability. Your invention must fulfill the criteria of industrial applicability. Means that invention must be used for some industrial purposes and must be that not be against our morality and the system of our country. Like few things cannot be filed for the industrial purposes, like gambling machine as such cannot be filed for the patent application because this is not the industrial applications. Like other few things cannot be filed for the patent application. I will discuss in our next slide. A few things cannot be granted as a patent application. Patents have the territorial rights. You can also apply for the patent application outside the India by two way. Either you can submit directly to that country or you can take the help of the PCT. What is the PCT? PCT is a patent cooperation treaty by which you can file a patent application in multiple countries. You have to select that countries in which you are going to file a patent application. So PCT is not a granting authority. It just forwarded your application to that country for the further process. They will help you for the patent searching, patent drafting, as well as for the submission of the patent report. But you have to pay the charges to the PCT for the such type of work. But you have to submit single application for multiple countries. Owner can also apply for the patent application. There are 4 official countries. If you want to file a patent application from Haryana, Punjab, and Himachal, then you can approach Patent Office Delhi, Southern Chennai, Western Mumbai, and the rest of India, Kolkata. How you can submit patent application? You can submit your patent application by three ways. You can submit your patent application by online mode, by post, or you can submit by hand also. So section 3 and section 4, I think these things are already discussed in the previous section. So I skip all these slides. Because basically my topic is related to the industrial designs. So as if we are talking about section 3 and section 4, section 3 and section 4 discuss about the non-patentable things like atomic energy as such cannot be filed for the patent application. Traditional knowledge cannot be filed for the patent application, which is already written in our literature, which is already written in our in some books and some videos that thing cannot be filed for the patent application. Scientific principle, theory as such cannot be filed for the patent application, like all the Newton's formulas. This is a theoretical thing concept. But maybe your invention is maybe your invention has some theoretical concept and that is in the tangible form. Then you can approach for the patent application. But as such, theory cannot be filed for the patent application. Abstract theory, discovery of natural substance, the substance which is already occurred in the nature, and that thing cannot be filed for the patent application. But you have genetically modified that natural substance, then you can approach for the patent application. New form of a known substance. Suppose if you are some molecule, some compounds. Suppose if you are from the chemistry background and you are just developing a new use of the existing compounds. Just because of the new use of the existing compound, patent cannot be granted because all the process is same, all the manufacturing things is same. But you have just developed a new use of the existing compound, the patent will not be granted. Means when you are developing a new compounds, then your compound must have some changes, major changes in your compounds. Means you are adding some new reactant, new chemical in that things, then you can approach for the patent application. Mixture of non-compound acids cannot be filed for the patent application. Suppose if you have a molecule A which is showing antipyretic activity and molecule B which shows the analgesic activity, and you combine both the compound A and B. Now they are representing AB as an analgesic activity and antipyretic activity. Such type of thing cannot be filed for the patent application. Method of agriculture, like all types of process which is used on the land, cannot be filed for the patent application. But if you have done some genetically modified application, like if you are developing some new instrument for the agriculture and horticulture, that instrument can be filed for the patent application. But the process used on the process used on the land, that thing cannot be filed for the patent application. The machinery, that technology by which you are using, which are increasing the efficacy of your agriculture process, horticulture process, then you can approach for the patent application. This is the website of the ipindia.gov.in, where you can find all the information related to the intellectual property. Like suppose if you are uh, want to file a patent application, then you have to click on the all the information related to patent is given there, design is there, trademark is there, geographical relation is there, and copyright is also there for the protection. As software is patentable, or yes or no? As so, software cannot be filed for the patent application, because if your software is connected to some hardware, then you can approach for the patent application as such, because your software is considered as a literary work, and your algorithm is not considered as an invention. In USA, software can be filed as a patent application because they consider your invention as a regarded as a novel and inventive step like other inventions. Our business method is patentable in India. Yes, business method cannot be filed as a patent application because rule and methods for doing a business are not be regarded as invention. Because if you are selling some few product by some online product, this is not an invention. This is strategy to sell your product in the market. Because for the patent filing application, I repeat three things. For the patent application, you have required three things: novelty, non-obvious, industrial applicability. That is major things, because if you are doing a business method, if you are developing some new business method, maybe it is novel, but that must not be having some inventive step like a Flipkart, Amazon. That is not an inventive step to sell the product, because many people are selling their products online through online portal. There are various forms to fill the patent application. Suppose if you are going to file a patent application, then you have to fill patent application form 1, form 2, form 3, and form 5. Form 1 basically simple application to fill all the information related to your invention, related to your applicant and inventor. And provisional specification and complete specification, basically the content of your patent application, which you are claiming for the patent application. There are two types of specification: provisional specification and complete specification. What is the difference between provisional specification and complete specification? Provisional specification, suppose if you have some idea in your mind, but you want to develop some your idea, and you want to protect at the initial state of your idea to the patent application, then you can approach for the patent application. Then your idea is locked for 12 months. Nobody can see your idea. That idea is locked for the 12 months. Suppose if somebody can claim after the few months of your filing of the petition, then priority will be given to you, because you are the first original inventor of that invention. But if you are not able to submit your complete specification within 12 months from the filing of the patent application, so if you are not able to submit your complete specification within 12 months, then your patent will not be considered, and it will be considered as amended. Next, form 3 is for the statement undertaking, and for form 5 is the declaration as an inventor step. So there are total 30 forms. Now, Government of India has reduced the fees of the educational institution. Now you have considered as a natural person. As previously, it was government fees for the patent application from the filing to request for examination and early publication is rupees 8,100 rupees. Now you have suppose sorry 41,000 rupees. Now you have to pay only 8,100 rupees. The government has reduced the fees for the educational institution also. Means previously it was 8,000 rupees for the educational institution. Now you have to pay only 1,600 rupees if you are going to file a patent application by the name of the education. Now government has, even for the small entity and for the MSME, they have to pay only 1,600. Means 8,000 only for the large entity. Just to create the awareness, just to motivate the inventor of our country, government has reduced the patent filing fees for the educational institution. So this is the anatomy of the patent application. Basically, the title of the invention, inventor and location of the invention, assignee, patent application, means all the information given there. So I will share with a few example of the iconic toy and game patents. Like this is the Cubic games. Everybody knows that Rubik Cubics, and this is patented in 1980 by the Rubik Cubes. The inventor is from the Indian inventor name is the Aaron Rubik, and the device was patented in 1983. On the classic Rubik's, each of the six faces is covered by the nine sticker, and each of one of the six colors white, red, blue, orange, red. There is a combination, and this is also mentioned in the Guinness World of Book of World Record also. Another example is the game related to the game is the Super Soaker. Super Soaker is the one of the most successful toy of all time, and they are selling a products by approximate 1 billion worth of product. Inventor Lonnie Johnson, a farmer in the United States of America, Air Force University, who experimentally developed such type of toy for selling in the market. Because now government of India is also focusing to the Indian manufacturer to manufacture new type of devices for the toy industry also. So they are specifically focused for the toy industry like this 92 Game Boy handle. This is also a popular uh, toy for the children in 90s because now they are people toy mostly children are using a mobile phone, but this is for the our generation game machine. They are playing game patents. This patent is patented in 1983 and they successfully launched in the market and they are selling a product in the market. So this is all are the examples related to the toy industry because toy industry nowadays are the upcoming and now we have to think. Now you can see this is the small things. You can protect your small things as a patent right also. You have to think how to, maybe it is a novel, maybe nobody can use such type of information. Even you can protect outer appearance of the device. We will discuss in our next slide for the industrial design how we can protect our outer appearance of the device. This is the process of the patent application. I think these things is already covered in the previous lecture. Another one is a trademark. Trademark basically are granted for sign, words, letter, color combination. How it look like, it's like Lux, Godrej. These all are the example of the uh, trademarks. Trademark basically to protect the brand name of the products. It does not represent it does not protect the technical feature, it does not protect the outer appearance. It protects only the outer appearance of it protects only the brand name of the products. Means nobody can use same type of brand name for the particular product or particular class. There are 45 classes of the trademarks, class 3 for the soap and detergent, class 5 for the medicine, class 7 for the machine tools, class 9 for the electronic components, class 30 for the food items. So this all are the example of the uh, trademarks. Now, if you are claiming for your brand name for the toys, then you have to apply your patent application class 28. 28 for the sports product as well as for the toy games, toys, playthings, video games. These all are example of the trademark related to toy industry. So I will skip these slides because basically we will discuss about. So this is very important slide for all. As a layman, we have to understand what is the role of the trademark. Medzol. Suppose if you are taking a medicine and some doctor has prescribed a medicine Medzol 200 for some type of disease. Basically, Medzol 200 is containing a medicament itraconazole 200, and itraconazole 200 is used for the allergic preparation. Suppose now here you are purchasing a Medzol from some other chemist from some other city, and they are giving you a product Medzol 200, and the product containing ismaprozole and albendazole. Now you can see there is a lot of difference between the chemical name. Itraconazole is used for the allergic preparation, and ismaprozole is for the gastric preparation, and albendazole for the kill the insects in the stomach. So basically, sometimes it's life threatening also. So be careful when you are purchasing a medicament by the name of brand name. Suppose when you are going to purchase, then you must read the what is the actual chemical name of the product because that plays very important role for the protection of the brand name. These all are the example of the trade, trademarks. You can also protect the outer appearance of the device, how it looks like. So you can protect shape of the goods by the trademark protection nowadays. How to select a trademark? That must be easy to spell, easy to pronounce, like Sony, Tata, Lines. You may also point few words like Kodak, Dada. As such, there is no meaning in the dictionary Kodak, Dada, Kodak and Dada. But you can develop such type of words. As such, you can point such type of words. Marks should not be according to geographical name like Ludhiana State, Chandigarh Sards, Ambala Steels. Avoid which describe the quality of the goods like best, perfect, super, pure, premium. Which describe the quality of the goods. This is the website of the trademark industry. You can search any brand name by the trademark portal. Suppose if you are filing a trademark in class 35, you can search brand name, enter class and brand name 35 for the L1. You can check any brand name yourself also as per your convenience. You have just entered the class. There are very classes already discussed. Class 3 for the children, class 5 for the medicines, class 7 for the machine tools, and class 35 for the old type of trading products. Suppose this is the example. Class 5 for the pharmaceutical products. Like some people are adding some word after the completion of the patent. This is totally trademark infringement. Your brand name must not be similar, phonetically similar to the existing. This is the example of the discipline medicament. This is used for the class 5. Class 10 for the medical surgical products. Class 44 for the hospitals. The government fees for the trademark filing is rupees 5,000 rupees for physical filing and 4,500 rupees for e-filing. Industrial design. Industrial design is very important because industrial design is easy to get as a IP rights in India. You can protect any outer appearance of the device with the help of industrial design. Industrial design basically to protect shape, configuration pattern. Any ornament feature, any aesthetic feature, and composition of line you can protect with the help of industrial design. Like this, you can protect any shape, but it does not protect any technical feature of the product. If you want to protect the technical feature, then you have to apply the patent application. Patent is basically to protect the technical feature and industrial design to protect the non-technical feature, outer appearance of the device. This is the example of the consumer product, which is protected by the industrial design. You can see also the design number on the product. Like if you are using a pressure cooker, you can see the design number below the pressure cooker. Why industries? Packaging containers. You can protect any packaging container. Means nobody can manufacture same type of packaging for particular products. Pharmaceutical products. Textile and jewelries. So your design must be new and original. That is the basic criteria for the filing of the registration. If you are applying for the already existing design, then your design will not be granted. That design must be new and original. You are the first inventor of that design application. Maybe the purposes of the design is same, but you can protect any outer appearance of the design. This is an example of industrial designs. Renault pen, where steel container of it is protected by the industrial. Hawkins pressure cooker, the outer appearance of the device. You will get a certificate like this after the completion of the process for the industrial design. You can protect device. This is the outer device. You can protect this type of devices as a industrial. This is basically for the mechanical purposes. Maybe the machinery is same in this device, but you can protect outer appearance of the device by the industrial. This is a case of the Ludhiana. Hero is the registered designs. They are selling the product by the product industrial design. And O1 is selling a product by the using same type of design. They are approaching to the court for the violation infringement of the industrial design. The duration of the industrial is 15 years from the date of the filing. Initially, you will get rights for the 10 years, but you can renew for the 5 years. Two things cannot be filed as industrial designs, like calendars, certificate, maps, architecture buildings. Architecture building as such cannot be filed for the industrial design. Mere mechanical construction, building flags, emblems, mere workshop alteration, mere change size. In our country, India, approximately 6,700 applications filed per year. In which 90% grant, 40% foreign filing, 60% from the Indian applicant. Where we are lacking basically. In our country, approximately 6,700 design applications filed, China 1.5 lakh, Korea 1.5 lakh, Japan 75 lakh. So this is the reason we have to think how to protect intellectual property rights. We have to grow. If you want to grow for the nations, for the reason, you have to protect your IP rights. You can protect your device by the multiple type of fiber protection, like Dyson Airplane. This device is used for the hand sanitizing and hand drying. You have to insert your hand in this device. This technology is protected by the patent rights. The brand name is protected by the trademark, and the outer appearance of this device is protected by the industrial design. And the literature matter, architecture, the literature matter is protected by the copyright protection. Copyright, this is the last right. Copyright basically granted for the literary work, artistic work, dramatic work, musical work. Copyright basically to protect the idea expressed in the material form. You can protect with the help of copyrights. As such, there is no official for the copyright. The moment you have created your work, it is protected by the copyrights. But you can also take the help of the government of India to protect your protections. Like suppose if you, but you have to show government of India will give you the rights that you are the first original author. If somebody can claim, somebody can claim these things is already covered, written by that person, then you can't claim for them no copyrights. There are two types of rights in the copyrights: moral rights and economic rights. Moral rights basically to protect the personality of the authors, and the economic rights to protect economic benefits of the authors. So some are the criminal remedies. You will get a penalty of rupees 50,000 rupees imprisonment 6 months to 3 years. Geographical indication are granted for basically three things: to protect the natural goods, manufactured goods, and agriculture goods of the particular regions. Basically, geographical indication are granted for the group of the clusters, like basmati rice, masoor soup, masoor sandalwood, masoor sandal soap, masoor jasmine. So these all are the example of the industrial design, like Darjeeling tea, Kolhapuri chappals. What is the difference between geographical indication and trademark? Geographical indication is basically to protect the rights of the particular geography. And the trademark protection is particularly to protect the identity of the individual. Trade secrets, few things cannot be filed for the patent application. Likewise, we had discussed, like in section 3, like business idea cannot be filed for the patent protection. Business idea cannot be protected by the patent rights. The information related to data survey, that thing cannot be filed with the patent rights. Then you can protect with the help of trade secrets. Like the formula of the Coca-Cola is protected by the trade secrets. Formula of the KFC burger is protected by the trade secrets. There's a one organization DL101, WIPO. They are running 1.5 month diploma for the general course on IPR. You have to click on the link wipo.int. This is totally free of cost. When you are applying this diploma, then you will get a certificate. There's another scheme, that is Department of Science and Technology managing this scheme, W Scientist Scheme C, in which they train 120 movements in the field of intellectual rights. How to write a patent, how to draft a patent. Thank you so much. If you have any questions, you are free to ask me. I'm sorry to all of you. Actually, I'm not feeling well, but still I'm trying to give you a best presentation. Thank you.
So much, sir. Thank you so much, sir. Actually, my screen got hanged, so it took 1 or 2 seconds to switch on it. Sir, if there will be any questions, people can put those questions in the chat box. Till then, if you permit, we can go with our next resource person of the day, Mr. Abhishek Avasti.
Yes.
Good morning, sir. How are you?
I'm good. I'm good. Thank you.
Thank you so much, sir. Sir, it's my proud privilege to introduce you to our audience. Mr. Abhishek Avasti is a mechanical engineer and registered patent agent. Presently, he is working as a manager, intellectual property rights in Hero Motocorp Limited, world's largest two-wheeler manufacturer. Over his professional tenure, which has spanned over 12 years, he has earlier worked in various companies, such as leading IP law firm in Delhi and R&D department of Tata Motors and Thomson Reuters, providing IP-related solutions for corporates and law firm in US, Europe, and India. He has extensive experience in IP strategy development, innovative life cycle management, patent filing, patent drafting, and patent prosecution. In addition, he has extensive experience in industrial design, searching industrial design, filing, and industrial design prosecution. Sir, we are very happy to have you with us. And it is our proud privilege to listen to you. So, dais is yours now.
All right. Am I audible to everyone here right now?
Yes, sir, you are audible.
Okay, so I would just share my screen and let me know if it is visible to everyone. Right. I hope you all can see the screen, right?
Right, so we can see the screen.
Okay. So I'll just turn the camera off and we can start that. So first of all, I would like to first of all thank Dr. Rahul Taneja for this excellent presentation he gave. He sort of made my job a little easy because he covered most of basics of IP. Specifically, since this industrial design part was covered by him, most of what I'm going to tell is already it has been touched upon. Having said that, so this industrial design, it's basically a subset of, it's a part of intellectual property rights. As discussed earlier, there are IPR are of various kinds. You have patents, you have design, you have trademark, you have copyright, you have trade secrets, and there are others as well. One of those is industrial design. And right now, today, I'm going to talk about what they mean, what's the perspective of the industry in India specifically on industrial design, what are the challenges, how the importance is changing or decreasing or increasing in the past few years, and what we see happening to this in the coming few years. This is just a brief of what we are going to cover today. Initially my discussion, then I'll just briefly touch upon what are designs, although it has been done by Dr. Taneja already. Then we'll talk about the recent trends in Indian companies for design registrations, and then some case laws that has shaped our understanding in terms of design registration, and how the companies have changed their policies or their approaches towards design based on the case laws that have happened in India and elsewhere. So first of all, as Dr. Anuradha told us, I'm Abhishek, I'm a parent agent. I have worked in the field of IP for the last 12 years. I worked with a law firm in Delhi and R&D departments of Tata Motors and Hero MotoCorp. Just to set things straight and set the disclaimer, whatever I'm going to tell right now or I'm going to speak about is not are not views of my current or ex-employers. These are my personal views. So don't take me to the court for it. Secondly, this presentation is merely for the purpose of academic value or interaction or sharing knowledge. It's not a legal advice. Okay, so take it in that sense only. And third part is that what many of the things that we are going to cover today are going to be based on the current case laws, current laws that are presently being applicable. What happens is that there are laws that are amended, there are more case laws come up, and then the understandings change. So tomorrow, if there is different understanding among the experts, it's bound to happen. Again, don't hold me responsible for any change in that. So with that disclaimer, so we should start. Now, what is a design registration? In USA, they call it design patents. In India, we call it design registrations or simply design. In Europe, they're called community design or registered community design. They're nothing, they are basically same, just multiple names for the same thing. What do they do? So design is that IP right that protects the ornamental appearance of an object. It protects how the object looks, not how the object works or performs. So a design can be a shape, pattern, arrangement of lines, color combination, which is ornamental in nature and that is applied to an article. Each and every word here is important. We're talking about a design that is applied to an article, applied using an industrial process. So if someone grows an apple or a mango that has a unique shape, it is not through an industrial process, so it can't be a design registration. Although it's, so if, for example, if someone grows an apple that's shaped like a heart, clearly attractive, but not design registrable subject matter. Okay, so you're talking about shape, pattern, arrangement of lines or color combination, and they are all applied to an article. Please keep this thing in mind. We are talking about an article on which the design is applied. Now, the term of design registration is 10 years. And if you choose to pay the required fees, you can extend it by five more years. What are the essentials of a design? Well, the features of the design should be eye-catching. Eye-catching as in, if you make a product, it should have a different eye-catching feature. We'll touch upon this point. It's a very interesting point of what makes a thing eye-catching and what not. But for understanding right now, let's assume that every design is supposed to have an eye-catching feature. Second, it has to be new or novel. Now, this requirement is there in patents and other IPRs as well, that you can't simply take a design of something else or someone else and, sorry. Okay, so the design has to be new and original, meaning that you can't just copy someone's design. You can't use someone else's design and claim it yours. In fact, even if it is your design that you have shown it to someone by way of a Facebook post or by way of something that is public, you yourself will not get or cannot get a patent on that. Two. Third point, that design should be applied to any article using an industrial process. So if you're making a painting in your house, it's not a design subject matter because that you making a painting is not an industrial process, right? Fourth, should not be functional and useful. So we are not saying that the article on which the design is applied should not be functional. Article may of course be functional, but that functionality should not be the feature of the design. So if you have any specific question on that, feel free to shoot. I'm happy to be interrupted, but feel free, or we can cover this question later on. But just to remind, the design essential, it's not, doesn't have to be useful. It doesn't have to be functional, the design. The next point, it should not be artistic in nature. It should not be a painting or a sculpture, because if it is a painting, as Dr. Taneja told us, the painting would be protected under copyright laws. Here you see, these are examples of design patents. There's a car there and then there's iPhone. Why designs are important, particularly in the current market, is because the looks and appearance of things nowadays tend to matter a lot. If you think they don't, then ask yourself this question. If you have two cars that function the same, that have the same mileage and the same output or whatever, one of them looks really bad and other looks good, which one you're going to choose? Obviously the one that looks better. In fact, I would argue that people will choose the car that looks better even if the performance is not good. Okay, just a snapshot for designs. What kind of protection you get or what things get protected any eye appealing or aesthetic features of a product. It can be a shape or configuration in 3D or 2D. If the design is created during the course of your employment with a company, of course, the employer may be the owner. Or if someone is sponsoring you to do a design project, then the sponsorer. In some cases, when the college students come up with the design, the colleges become the owner. And of course, end of the day, creator is also owner if there's no other party or financier involved. The term is 15 years, easy to understand. Example, the entire car or the steering wheel or toys. Now, unlike copyright or some other forms of IPR, there is a formal application required. You are required to go to a patent office and ask them to give you a design. If you don't do that, you will not get a design. So it was not the case with copyrights. The moment you make a painting or a drawing, you are a by default copyright owner of the design of the painting. But for patents and design, the responsibility is on you to go to patent office and tell them that you have made this, and they may or may not give you the patent or a design registration on that. And once you have this design registered, you can stop others from using it. Now let's see what's going on in India in particular. Again, I think Dr. Rahul already covered this, but I'll just try to give you a snapshot. See, design registrations are comparatively easy to get as compared to patents. It's comparatively less expensive to get design registration as compared to patents. But also, unfortunately, there are fewer design patents that are filed in India and arguably everywhere as compared to patents. You see the trend, the last annual report of patent office that's available, about 12,000 design registrations were filed in the financial year of 18-19. If you compare that, in the same period, more than 50,000 patents were filed in India. So clearly, they are lagging behind in terms of numbers, but there is a steady, constant growth over the years. And if you look at the growth in particular, you will find that there is a higher extent of growth by Indian applicants. So when there were 9,000 in 2014, we have got 12,000 in 2018-19. Sorry, 6,000 to 8,000. So the increase is higher within the Indian community when we talk about design patent filing. State by state, the stat of the states, just like in patents, Maharashtra is leading, followed by Delhi, Gujarat, and West Bengal. Haryana, I would not say is leading, but is definitely not in the bottom, in the middle somewhere. And just because Maharashtra and Delhi can do it, I'm sure Haryana and Rajasthan can also do it. So I think everyone should buckle up and try to become a leader in terms of design filing. There's lots of potential, and we as a state can do that. Now let's talk about some case laws. So I'll try to make them as simple as possible at the expense of being oversimplistic to the audience who are not well versed with the law, and of course those who are will obviously understand. But even those who are, I'll try to simplify all the cases that I'm going to present, and how those cases have shaped the way the industry and people in general are now seeing design patterns. So in an attempt to be a little more simple, I'm not going to use technical jargons, legal jargons, and try to keep everything simple. So there is this company in India called Marico Industries, and it's a FMCG giant. Their products include Parachute and various others. They had a design patent on the one of their product, and that was registered in 2000. Sorry, registered in 1999. There is also a company, probably more famous in some part of the India than northern part of India, but I think people may have heard of it. Raj Oils Limited, and they have their product called Coco Raj. So those who are old enough like me would probably recall back in the 90s, there was this ad campaign run by Parachute where they talked about an innovative dhakkan of their bottle, innovative cap. They used to call it Kamal ka dhakkan. So what this cap essentially is that you can unscrew and open it like you do to a conventional box cap. But there is also a openable tab kind of structure on the top of the cap. I think everyone can see this. So like when, and it essentially containing coconut oil. Coconut oil has this quality of getting, solidified easily when there is a winter season and being liquid when there is a summer season. And so you can have the same bottle and the same cap. You can use the same cap in a different manner based on the season you are in. So in winter, you can just unscrew the cap and take the oil out, or whereas in summer, you just open the tap and you can pour the oil out of it. So for them, of course, it was a good product, and their entire ad campaign was designed around this Kamal ka Dhakkan, so much so that even now this Dhakkan is prevalent. Now, in 1999, they filed a design patent for the cap. They got a design patent for that. 6 years down the line, about 2006, they may have seen Coco Raj. The product was owned by Raj Oils. Them selling a cap which seemed to have, as per them, same design. Again, screw kind of connection on the side, and then on top there was this tab kind of opening that can be closed by using one finger. So I'm sorry. Obviously, since the design of Parachute cap was registered, they went on September 2006, they filed a case against Raj Oils, alleging that you are infringing my patent and you have to stop selling the caps, and all the caps that you have manufactured thus now and is lying in your plant, you have to discard it, and whatever the bottles that are there already with the dealers or sellers, you have to ask them to stop selling it, and so on and so forth. Now let's, of course, Coco Raj or Raj Oil did not accept that they were infringing it. They went to the court. And then there's some interesting thing happened. So this interesting thing is applicable to all the forms of IP. So when someone files a case against you for infringement, if you can somehow cancel their design registration, that can be a ground of defense for you. So in simple terms, for example, if you are living in a house that has been given to you by the landlord, you're a tenant there. and after some time you are not vacating, and the landlord comes to you saying that, okay, you give me this much money or you vacate the house, or maybe files a case. If you can somehow prove that this landlord is not the landlord, then his case doesn't hold. That can be your defense against the landlord. Similarly, this thing happens in design registration, it happens in patent registration as well. If you can somehow cancel the design itself, you have basically defended yourself. So that's the approach that Raj Oil basically took. And they went to the court saying that the design patent is given to an article. And then what an article means, any article of manufacture or substance, artificial or partially natural, and includes any part of an article capable of being made and sold separately. Now, I want to request all of you to think that can a cap of a coconut oil bottle be sold separately? I don't think there is any shop in which you see the caps being sold separately. So these caps are sold, but not the cap that we are talking about. If we zoom further in this section, you will see that there is a thing about capable of being made and sold separately. So question basically then turned into whether a cap of a coconut bottle qualifies as an article within the definitions as per the Design Act. As per Kokoraj, it wasn't because it's not capable of being made and sold separately, which to a layman would seem that, yeah, it's quite possible. And this is what they used as a defense. And they tried to cancel the design of parachute cap under Section 9. Yeah, let's go back. There was a long back and forth between the courts and the advocates of both the parties. And something very interesting happened. The judge eventually decided that although cap, not this cap, but the cap of the bottle, is an entity which is essentially going to be a part of the cap. No one has probably seen a shop or a company that is selling only the cap. But if the judge says that if we looked into the law in such plain mechanical meaning, it will be difficult to provide coverage to design owners. In other words, it says that the cap is capable of being sold and made separately. It is, although someone is not doing it, but certainly it can be done. It is capable of being made and sold separately. So counterintuitive it might seem, but the cap itself was established as an article. In other words, Kokoraj could not cancel the registration of the Marico Industries cap because their argument that the article cap is not an article as per the Design Act was not accepted by the court. Now let's park this idea for a second, and we'll cover that what are the implications of this idea in the industry. So now you would assume that the Kokoraj could not cancel the design patent of parachute and they would have lost the case. But then something interesting happened. If you look back on the two designs, the working of these two caps might be same, meaning that the way they work, the way a user is required to unscrew it when it wants to use it in the winter season or open the tap, it might be same. But do they look identical to you? I don't think so. And the codes went to the very, very basic difference between patent and design, which is design give you coverage to the aesthetic features of the cap. If you look at the cap on the right, clearly the top part is different. The location of that tab is different. Even the color is slightly different. Dimensions are different. The cap of parachute has a sign logo of parachute on top of it. That same logo is obviously not there in the Coco Raj oil. In other words, there is no likelihood of confusion. Functionality, it will be same, but Coco Raj, of course, tried to use the same functionality that parachute had, but it did not look identical. The sole purpose of design patent was to stop someone from using the design that looks identical. They may function the same in this case, but since they are not identical. So here's the verdict that came out, that there is a clear different mark name with parachute and Coco Raj with a tick mark symbol on the parachute bottle. There is a single drop shape mark on Coco Raj bottle. So basically the names itself were different. The dimensions are different. In a way, the shapes were different. So had it been a patent, a utility patent, maybe parachute may have won it, but purely on the looks, in this case, they were not identical, and Coco Raj managed to defend itself. And the allegation by parachute that Coco Raj is trying to copy, it's infringing its design rights, were cancelled. The production of and sales of those bottles and coconut oil continued. Now, coming to the implications this had. Because of this, one thought process that was established or became firm among the fraternity was that the definition of article is now a little broader, even broader. So if you are making a car, not only do you register the design of the car, but you also go ahead and register the parts of the car, for example, a headlight or a steering wheel. So, and if you are designing something else of which there can be parts that can theoretically be made or sold separately. Prior to this case, maybe people would have chosen to not file the design registration for those parts. But this case law basically incentivized those who are registering even the parts of the components. And secondly, of course, this case law established that the purpose of patent is different and the purpose of design patents are different. And therefore, Coco Raj won. So the key takeaways: patent also the parts, not just the entire component, wherever possible. This did lead to or leads to increased number of patent filing. Probably the patent office wants that. That's why this verdict came. You never know. But the verdict was that you file more patents even for the parts. Now, the next case is Crocs versus every footwear manufacturer company. No, it's not that. It was Crocs Incorporated USA versus Bata, Liberty, Action, Aqualite, Relaxo, and so on and so forth. This is the second case we are talking about today. And the gentleman you see in the bottom is Mr. Bata himself. I don't think there would be anyone in the panel today who wouldn't have seen Crocs footwear. Has anyone seen that? No, this crocodile is not there in the branding. I'm just trying to signify what Crocs is. Now, this Crocs, as you all would know, or may know, is a US company. Their floaters or slippers, called as Crocs, are pretty famous almost everywhere in the world. And of course, in India. But surprisingly, in India and probably everywhere else, there are Crocs or Croc-shaped footwear sold by every manufacturer, almost every manufacturer. So, somewhere in 2006 or 7, Crocs decided that enough is enough. Since we have the design registrations, we are going to bring everyone to court. They filed a giant lawsuit against Bata, Liberty, Action, Equalite, BioWorld Merchandising, Relaxo Footwear, and this company called Kids Palace. Being a US giant, it had registrations on the designs of the Croc footwear for all the various models. And incidentally, prima facie at least, it seemed that all the Indian manufacturers were actually using the same design. The case went to court, and in defense, Bata and these defendants proved that the design patent that were filed by Crocs were filed in 2002, but the website of Crocs had images of same shoes in 2000. I will just reiterate this point so that everyone understands it. What Bata and the defendants could prove that the design registration based on which Crocs was filing cases against them, those design registrations were filed in 2002. However, the website of Crocs had images of those shoes as earlier as 2000. Now, as Dr. Taneja told you earlier, and I also am trying to tell you, and probably you already know, if you have disclosed your design to public, you lose your right to get a patent on that. Whether it's a patent and or a design patent. It doesn't matter whether a disclosure was done by you or by your enemy, or it was done by with your consent or without your knowledge. If your invention is known to public, before you file it, the disclosure itself will act as prior art, and your patent or design is bound to be or can be cancelled. That's one point. Second point is what I said earlier, that in a suit of infringement, if you can prove that the design registered or a patent registered is invalid, that becomes a defense for you. No, the example of landlord or tenant I gave. So coming back to this case, when the Batas and the defendants, they established that the Crocs footwear, or at least the images thereof, were available in public domain years before the design patents were filed. And based on this, they could invalidate the patents of Crocs, and eventually they won the case or basically they protected themselves from the damages that sought from them by crocs. Again, industrial takeaways or takeaways for everyone who understands this is be super cautious with regard to what you reveal to the world before filing a patent. Because if you reveal it before filing a patent, you end up giving away, your right to get patent on it later on. There was one more case. Is there any question that I need to take? So there's one more case going on in which Honda has sued the design of a e-scooter. Not go deep in this one right now. I would request everyone to please be on mute. There's voice coming from someone. Thank you. Thank you. Now this is it's just a off topic, but I still cover this. We keep on seeing these news articles every now and again that images are leaked, patent images are leaked. Then you see drawings of upcoming products. As recent as last year, we saw this news article wherein the images of Nissan Magnite were allegedly leaked. Well, the eminent authors or writers of this book, they probably forget that this is not actually a leaked image as such. Whenever a design patent is filed, or a patent is filed for that matter, after a certain period of time, those applications, or at least parts thereof, are published in a journal, to make it available for people to see or oppose it. That's what happened at times when some people see it as a leaked image and then they make an article out of it. Next time when you see this leaked kind of article, assume that it's a proper patent and they are
அதுக்கப்புறம் காலம் அழகா கிரியேட் பண்ணி அந்த ஹெட்டிங் போட்டு போட்டு நல்லா நீட்டா எழுதணும் போட்டு சும்மா கடமைக்கெல்லாம் எழுதுனீங்கன்னா பிரசன்டேஷன் தான் நீட்டா இருக்கணும்.
I would request everyone to be on mute, please.
நல்ல மார்க் போடுவாங்க. நீ ஆன்சர் தப்பா இருந்தா அதுக்கு பிரசன்டேஷன் மார்க் நல்லா போடுவாங்க. சரியா? ஏற்கனவே சொல்லிருப்பாங்க. அப்படிதானே போடுவீங்க. ஹெட்டிங் வந்து எப்பவும் கேபிட்டல் லெட்டர்ல இருக்கணும். சரியா?
Sir, kindly unmute yourself. I have muted all.
Oh, that was really impressive. A shortcut to mute everyone. Great. Okay. Now, so these are some links that I have compiled. Okay, for everyone who is interested in knowing a little bit more about IP, they can simply go on these links. The first link is, I think, some link that was already shared by Dr. Taneja, and I didn't know his content, that's why I covered it anyways. So this is the World Intellectual Property Organization. It basically oversees and regulates, not controls, but formulates IP across the world. And they have their IP Academy, full-time and part-time, online or offline, all kinds of courses are there. And some of them are free and some of them are paid. But if anyone among the audience is developing any kind of initial interest in this, or wants to know more about IP, not just design patents. I like design patents more because I am a mechanical engineer. I have done AutoCAD and CAD in my academics. So whatever I do professionally, 1% of mine is always dip into design. So I like design more. But if anyone is interested in any form of IP, patent, design, copyright, whatever, this WIPO Academy, it has various courses, and few of them, at least a couple of ones that I know of, are free, just require 42 hours of studying digitally, virtually, and then if you pass, you get a certificate, a physical certificate they send across right from their head office. And it can be a good start for those who are not very much into IP and want to learn more about it. It's a very nice, free-flowing website, and it will give you a good shortcut or way to enter in the field of IP. Then there is European Patent Office website. Now this is of course for learning, but on that website, you will also be able to see the design patents that are already filed in Europe. Now, why is it that important and how is that important is that initially I told you that design patents have a finite term. Like design patent also have a finite term. So a patent can have a maximum term of 20 years. Design patents have a maximum term of 15 years. 10 years generally, 5 years can be extendable. What that means is that after 5 years, after 15 years, all the design patents that were filed or all the utility patents that were filed before that 20 years period are now free for you and me to use. Essentially, all the patents are a solution to a problem, one way or the other. All the design patents are, to someone's opinion, an aesthetically appealing product. When the term is over, you and me, or theoretically anyone, can safely, freely, legally use those products or technologies or your designs. So try to understand, there is an ocean of wealth of knowledge that's there in every patent database, only extracted from the expired patents and expired designs. If we know how to use these patent databases, we can go there and find patents that are expired and are, with full legality available for you and me to use. There's nothing wrong in that. As such, each and every patent is nothing but a solution to a problem that someone saw. No one files a patent or design patent for no reason. Moreover, if you are trying to solve a problem, a simple problem, maybe unlocking or something, is it likely that somewhere in the world would have also faced the same problem? I think quite possibly. And if someone somewhere in the world tried to solve the same problem, did you file a patent? If yes, and you can manage to find that problem, you don't have to reinvent the wheel. Just harness the solution that someone else came up with already. That's the very purpose of the entire patent system in India or globally. You tell your invention to the world. In exchange, the governments give you right or monopoly for a certain period of time. When that time period is over, your invention is free for public. So I would request those interested to go to this European Patent Office website. There is Google patents also. There are paid databases. There's a database from Indian Patent Office. Simply go there and see the patents that are being filed and that are getting expired. You never know where you can get different clues from. Coming back to learning opportunity, this SWAYAM is a good initiative by Government of India. They are all virtual, non-physical courses. And then there are courses by FICCI. They also have virtual seminars as well along with the academic courses. If I do get to share this website to the organizers, you can catch hold of this PPT and get those links. If not, you can get my details and then I'll share with you these links individually. Now, so before we end, there are some things that I want every one of you to remember. If you don't remember anything from the entire presentation, I am fine with it. But at least try to remember these do's and don'ts. They are for your own good. Don'ts. Assuming you have an idea, okay, whether it's for a design patent or you don't know what that is. You're simply not sure which kind of IP that qualifies. You just one day came up with an idea that I'll do this and that will happen. Don't, if you are a student or a faculty, don't discuss it with anyone outside the IP cell. Okay. Or if you want to do with someone, make sure there is an NDA in place. NDA stands for non-disclosure agreement. So if you tell the idea to someone who has signed an NDA, still fine. Otherwise, you telling him the idea, this guy or girl will say thank you very much and go sell that idea to anyone he wants to. Just to reiterate, don't discuss with the idea with anyone outside your IP cell. If you don't have an IP cell, you contact the organizers of this seminar. They will probably let you know. But to be safe, don't tell it to anyone. Not just tell, you shouldn't make your idea public. If you are serious about the idea, you should not go to Facebook and post about that idea. You should not make a blog post about it. A very common mistakes that students generally do is, and I am surprised to see that that's still continuing and probably growing. They have an inclination towards filing research papers. I'm sure filing research papers has their own benefits and advantages. But one thing is for sure, that the day that paper becomes public, your possibility of getting a patent dies. So you should weigh in the benefits and disadvantages of doing that. So going back to the point, do not make your idea public, either before at least filing a provisional patent. Provisional patent is just a beginning, it gives you an initial kind of protection, gives you 12 months of time to file the complete application. At least you can do that. It doesn't cost much. Or to be safe, don't disclose it to public before filing. If for your idea, you are working with contractors or suppliers, or there's someone who's making an app for you or a website for you, or you are someone making a prototype, there should be an NDA with them. There should be a contract, as simple as that. Do not try to copy an existing patent. So in the earlier slide, I said that you can copy patent. Now I am saying you cannot copy an existing patent. Well, right now in this point, I'm talking about an existing patent that has life left. Earlier, I was talking about expired patents. So if there is a patent in place and you choose to copy it, you're flirting with danger, you're playing with fire, because if that patent owner comes to know about this, you might be in danger. This is the next point is a very important point, and I want everyone to understand this, please. Patent office does not require from you samples or prototypes. Okay, so if you have thought of an engine that works with water and you can theoretically prove it, the patent office is not going to ask you to provide a sample or a prototype. Don't invest time, money, energy in developing a prototype for the purposes of patent procedures. If you want to make it for other reasons, feel free. But for getting a patent or a design patent for that matter, patent office is not going to ask you for samples or prototypes. Don't invest time in that. If your idea is a business method, then patent office is not going to ask you for the app or a website. Just describe it and that's fine. The last point is never assume your idea to be inconsequential or even just a minor. You would be surprised that how small improvements have led to huge developments. small changes in the current existing things can be super improvement. Do not undersell yourself. Do not sell your idea is just faltu. You never know what can come out of it. What to do? I would suggest that you maintain some kind of a book. Whenever the idea comes, you write it down. You never know again when can a life-changing idea come to you. Be in touch with your college or IP cell as soon as an idea comes to you or to someone have it documented either by way of a mail or something, that your name is established, your date is established, and then obviously if eventually the decision can be taken on whether you want to file a patent or not. Keep in mind of the patent application timeline. As I said, don't disclose. Fourth point is important, that don't assume that if there is nothing right now, no one is working on it. What I mean by that is, if suppose you come up with a solution today, solution to a problem, and you know that there's no solution to the problem currently, you can't be sure that someone is not working on the solution. Meaning that if you delay filing your patent by a month or a year, there is just certainly chance that someone else might be working on the same technology at the same time. It's just that you don't know. Don't be in simple terms lazy about getting a protection. Again, you'll be surprised to see how closely fought the 1 or 2 days can be when with regard to filing patents on new technologies. And the last point is in connection to the same. Consider filing a provisional application in order to get an early right on the idea. If you file a patent provisional application, then you can work on the details and you can take your own sweet time. Maximum of 12 months, that is. You have to file a complete application within 12 months. But consider filing a provisional application as early as possible. The links again. Okay, now I would want to open the floor to questions if anyone has.
Thank you so much, sir, for your wonderful presentation. The dais is open for all the participants. आप अपने आप को म्यूट कर सकते हैं, and you can ask questions yourself or you can ask questions in chat box. Dear participants, you can ask your questions either in chat box or you can ask directly. You can unmute yourself. Sir, there is no question in the chat box, but if there will be any question later on in the WhatsApp group or in chat box, I'll mail the questions to you.
Sure.
Right, sir. Now I invite Mrs. Barkha from Chaudhary Ishwar Singh Kanya Mahavidyalaya for formal vote of thanks.
Okay, am I audible?
Yes, ma'am, you are audible.
Okay. Good morning to all of you. I deemed it a great honor and privilege to propose the vote of thanks on this memorable occasion. Let me first of all start by giving glory to the Almighty God for making today's occasion a resounding success. I, on the behalf of IQ-AC team of Chaudhary Ishwar Singh Kanya Mahavidyalaya Dant and collaborative IQ-AC team of M.D.S.D Girls College, Ambala City, a mentor college, thanks to our special guest, Dr. Rahul Taneja, scientist of Patent Information Center, Intellectual Property Facilitation Center for MSMEs, and Mr. Abhishek Awasthi, in-house counsel at Hero Motorcorp, who despite their busy schedule have found time to grace this occasion and share their knowledge about industrial designing to our participants. We are grateful to our principal, some assessment and accreditation ambassador, Dr. Kiran Agra, for her words of encouragement. I thank all the distinguished invitees present here accepting our invitation. Last but not the least, I thank you, my friends, for your cooperation in making this function a resounding success. Once again, I thank you for all for your attention. Thank you very much.
Thank you so much, ma'am, for your kind words. Now I invite our NAC coordinator, Mrs. Nishu Bansal, for her concluding remarks.
Thanks, Anuradha. A very good morning to all of you. Today's honorable speaker, Dr. Abhishek Awasthi ji and Dr. Rahul Tuneja ji, my IQAC team, Madam Principal, Assessment and Accreditation Ambassador, Dr. Kiran Agra, and our mentee college, CIS KMV, Dhant, Principal, Madam Vimla ji, and my dear participants. Dear participants, we have organized this 5-day online webinar on IPR, Industrial Academia Innovative Practices, being this is a very important criteria under NAC, and we UG colleges usually lose marks in this criteria. For this, I want to thank from the bottom of my heart to our Assessment and Accreditation Ambassador, Dr. Kiran Agra, for motivating us to organize a series of webinars on IPR and especially Industrial Academia Innovative Practices. That how an academic and a college can develop an IPR and how it is useful in industry. And that is really beautifully explained by our distinguished speakers. First of all, my thanks goes to Dr. Ashwini Siwal. His support during the whole webinar is commendable. He told us about the importance of IPR. Dr. Pankaj Tyagi ji, who told us about skill development with special reference to patents. Dr. Jayant Ghosh has told us about the startups, that how VUG college can open a startup, even in Hindi, in English, and even in commerce, we can open startup. So जो हमारे माइंड में ये रहता था कि हम यूजी कॉलेज क्या करेंगे, तो वो हमारा एक हिच जो है इससे जरूर दूर हुआ सर. Thank you very much for this. Then Dr. Pikshis Rohi, who taught us कि laws क्या कहते हैं, trademark law क्या है. And next speaker is Victor Vaibhav Tandon, जिन्होंने इंडस्ट्री के पर्सपेक्टिव से पेटेंट की इम्पोर्टेंस हमें समझाई. साथ ही साथ हमने कॉपीराइट के बारे में सीखा कि कॉपीराइट जो है ई कंटेंट हम डेवलप कर रहे हैं, कहीं हम कॉपीराइट में तो फंस नहीं रहे हैं. हमारे कुछ डाउट्स थे कि क्या हम कॉपीराइट कैसे कर सकते हैं. एंड आवर टुडेज स्पीकर डॉक्टर राहुल तनेजा जी, जिन्होंने हमें इंडस्ट्रियल डिजाइन के बारे में बताया और बताया कि कैसे इंडस्ट्रियल डिजाइन जो है वो अक्वायर करना इजी है इन कंपैरिजन टू पेटेंट. एंड मिस्टर अभिषेक अवस्थी, जिन्होंने हमें इंडस्ट्रियल डिजाइन में बताया कि हम आगे कैसे कर सकते हैं, व्हाट आर द डिफरेंस बिटवीन द कॉपीराइट एंड द इंडस्ट्रियल डिजाइन, एंड how we can with the help of industry, how we can go for industrial design. So I want to thank all the speakers and my IPC team, जो कि पिछले 5 दिन से लगातार इस पे लगी हुई है. और सबसे अंत में मैं धन्यवाद करना चाहती हूँ अपने पार्टिसिपेंट्स का, जो हर रोज सुबह 10 बजे अपना ज्वाइन कर लेते हैं हमें जूम पे. आजकल एडमिशंस चल रही हैं, बट इन स्पाइट ऑफ दैट वो कंसिस्टेंटली पिछले 5 दिनों से हमारे साथ हैं. तो आप सभी का धन्यवाद. थैंक यू वेरी मच.
Thank you so much, ma'am. Dear participants, today was the last day of webinar series. Now I request you kindly join us in the evening at 3 o'clock for final session of faculty development program. And there is one more request that we have sent a feedback form in the chat box. Kindly fill it. Meeting is open for next 10 to 15 minutes. After filling the feedback form, you can leave the meeting. Thank you so much.